Hello and welcome to my channel. I am your SPARX stenographer. Today I am going to deliver you a legal dictation and the transcription number 10. If you guys like my video, then subscribe my channel and also join me on WhatsApp. And the previous legal dictations also in the description box. So guys, ready for the dictation? 10 seconds. 5 seconds. Start. Having noticed the silent fact on which there is not much dispute, this court is firstly constrained to observe that there is no material or evidence to indicate what steps the corporation took between 30 April 1996 to 3rd April 1998. There is not one shred of evidence to indicate as to whether any notice was issued to the pensioner during the period of participate in the disciplinary proceedings. As noticed above, although the order dated 24 April 1998 asserts that various dates had been fixed by the inquiry officer appointed on 17 February 1997. No such notice has been placed on the record, nor have details of any such notice been allotted to or disclosed in the affidavit filed in these proceedings on behalf of the corporation. Even the order sheet which stands appended along with the counter affidavit of the corporation refer to dates which were fixed in 1996. On the above statement of the record, the submission of the learned counsel for the petitioner that the disciplinary proceedings were revived only in 1998 after a long spell of unexplained silence and inaction appears to have force. On 17 February 1998, the corporations, also being fully aware of the pendency of the disciplinary proceedings, proceeded to pass an order holding that the petitioner would be treated to have retired from service with effect from 31st January 1998. If the petitioner was permitted to retire with effect from 31st January 1998, this court fails to comprehend what authority inherent in the cooperation to proceed with or continue to disciplinary proceedings or to inflict any punishment upon the petitioner. As noted above, no statutory provision, rule, or regulation prevalent in the corporation was referred to or relied upon to sustain the continuance of the disciplinary proceedings after the retirement of the petitioner on 31st January 1998. Once the petitioner had retired from service, no authority vested in the corporation to continue with the disciplinary proceeding which had been initiated against the petitioner retirement of the employee cuts the cord which connect two entities and servers all relationship of master and servant or employer and employee. The retirement of an employee brings the curtain down upon the relationship of employer and employee. Once this event occurs, no further jurisdiction or authority vested in the employer to inflict any punishment upon the employee thereafter. Even otherwise, the following facts also need to be highlighted. Admittedly, the inquiry report was submitted on 19 February 1998. A reading of the said report, which stand appended in Exchequer 14, clearly shows that the inquiry officer has not recorded his satisfaction in respect of the guilt of the petitioner on the basis of any material or evidence on record. The only conclusion recorded by the inquiry officer is that since the petitioner did not cooperate with the disciplinary proceedings, that from his conduct it is clear that he does not want to proceeding to be conducted. He had no option but to record a finding that the charges stand proved. It is tried law that even if disciplinary proceedings are continued and culminate, ultimately expirate, the inquiry officer is under a positive obligation to record his satisfaction with respect to the charges leveled against the delinquent employee with reference to the evidence based upon which the employer seeks to take action against the employee. Even this rudimentary and settled principle was not borne in mind by the inquiry officer. The mistake committed by the inquiry officer, as noted above, was reiterated by the disciplinary authority inasmuch as neither in the order dated 24 April 1998 nor in the order dated 13 August 1999 has the disciplinary authority recorded any independent satisfaction with respect to the guilt of the petitioner based upon the evidence or material on record. This, of course, subject to the caveat that the failure of the inquiry officer to record this conclusion on each charge is not a flaw which could perhaps have been cured by the disciplinary authority for the first time. Stop.